So my name's Matt Billingsley. About, say, 8 years ago, I started talking to families in Dorset about disabled person trusts, wills, deputyships, powers of attorney, quite happily bumbling along because it didn't impact me personally, so it's much easier to be objective. Just over 2 years ago, this is Edith here. 2 years ago, me and Louise, who sat over, give everyone a wave. We received the news of a diagnosis of Rett from the doctors in our medical team. I don't have to tell everybody in this room, you get it. It was the worst day of my life, absolutely horrific. And then all of a sudden, I found myself as a legal professional with a foot in the legal world and a foot in the world of Rett and being a parent to a SEND child. So complete and utter change from what I expected. That's it. So the presentation will broadly cover the role, responsibilities, decision-making process of being a deputy for somebody, with a particular focus on personal welfare deputyship. Obviously, I'm a lawyer, so there's a disclaimer here. Anything I'm discussing today doesn't constitute legal advice. So I'm not going to be held liable, neither are Reverse Rett. Particularly Andy won't be, so yeah. And I'm qualified in English and Welsh law, not Scottish law, not Irish law. If I've got, I know Catherine's here, I know people, I can direct people to not in England and Wales, so please reach out, let me know, and we can go from there. So I think it's really important to recognise that, particularly prior to 18, there's a piece of legislation called the Mental Capacity Act from 2005, which enables you as parents with parental responsibility to make health and welfare decisions for your children. The key parts of the legislation, fundamentally, you need to presume that somebody's got capacity to make their own decisions prior to being adjudged not to. There's the 5 principles: presumption of capacity, somebody's got the right to make unwise decisions, all steps must be taken to help somebody try and make a decision if they can, any act's got to be done in somebody's best interests, and you've got to kind of proceed with the least restrictive option as possible. I bandy the word capacity around really easily, just expecting people to think that they know what it means. Capacity is a really complicated legal concept. Different areas of law have different capacity tests associated with them. So a will, for example, the test for capacity is a case called Banks v Goodfellow from 1837, which shows how quickly law moves, to be quite blunt. In the terms of the Mental Capacity Act, the capacity test really, into its most simple terms, is boiled down to: does somebody have an impairment of their mind or brain due to an illness or external factors such as alcohol or drug use? And if so, does this impairment mean the person is unable to make a specific decision when they need to? So people can lack capacity to make decisions, but have capacity to make others. It can fluctuate with time. I saw somebody last week to do a deputyship application, an elderly lady who's got dementia. One part of the day she's okay, another part of the day she's not okay. So it's when you come to kind of assessing somebody with a doctor, it's time and decision specific. So there's no one test or one answer for everybody. So the Act states that a person's unable to make a decision if they can't understand the information relevant to the decision, retain the information for long enough to make a decision, use or weigh up the information as part of the process of making said decision, or communicate their decision in any way. And I've given a lot of thought to somebody with Rett Syndrome that actually, with speaking from personal experience with Edith, although she can't talk or communicate verbally, I take one look at into her eyes, and I know that she knows. I feel that she can understand what she's doing or what she wants. And I just think that shows the difficulty around kind of assessing somebody's capacity to make their own decisions, particularly in light of such significant decisions as we've been discussing today. Sorry, where's it's locked itself? Yeah. Yes, you might as well just stay there, honestly. Yeah. Oh, there you go.
Just keep moving the mouse a bit. So.
Yeah, of course. Thank you. So one of the questions I tend to get asked is, do you actually need to make an application to the Court of Protection, or can decisions be made without going to the emotional trauma of doing so? Broadly, the 5 principles I mentioned earlier, and I'll just say I've done quite extensive notes on today, which I'm going to share with everybody. So not that anybody is making notes, but if you were going to, you certainly don't need to. So those 5 principles broadly allow protection for carers, so parents, healthcare and social care staff, to carry out certain tasks in relation to the person, which can include personal care or treatment of somebody who lacks the capacity to consent. So broadly, the principles enable you to take action or make a decision in the best interests of somebody who lacks capacity, and find ways of settling disagreements about actions or decisions. I think it's a case of there are important limitations as to what decisions can be carried out. So it might be necessary to apply to the Court of Protection where it's decision concerning treatment to which somebody cannot consent, or if the decision is difficult or complex. So clearly in that regard, I'm thinking about genetic therapy. So me as a father to a child under 18, broadly I can consent to her undertaking that kind of treatment. As I come on to later, the difficulty is as soon as somebody turns 18, in the eyes of the law, they're an adult and they can, with all the rights and responsibilities that comes with. The problem with that is, of course, that can be quite a cliff edge. I know speaking to some of the parents here about they've got children over 18, that's certainly something that they're concerned with. So I think if you're considering making a personal welfare application, you've got to take particular care to establish whether the Court of Protection can make the decision, whether you can make the decision without applying to the Court of Protection. Unfortunately, the court being the court, if they decide the application is not necessary, you'll be liable to pay the costs and court fees. Most care and treatment decisions can broadly be made by people involved in providing care if they're acting in the person's best interests. The Court of Protection will only appoint deputies in the most difficult cases. For example, if there's a history of disputes within the family where the person's at high risk of abuse, or I think this is key, when there is a need for someone to make a series of linked welfare decisions over time. I think particularly in reference to, with Edith, we've been part of the Rett community for a couple of years, and we've already had to make a series of, I say we, Louise, has had to make a series of interlinked decisions over time, which they might seem small and inconsequential when taken separately, but I think those little bite-sized elements really add up, certainly over the years and decades of which you'll be involved in your young person or young adult's care. So I told you I'm not used to slides. So in terms of, I'm sure everybody here has heard the word deputyship and lasting powers of attorney. So a lasting power of attorney is a document you can enter into when you're over 18 and you can make the decision to do so. So I've got powers of attorney for finance and for health, which I've created myself, naming Louise and my dad as my attorneys. If I suffer a brain injury or I lack capacity to make my own health decisions, then Louise and my dad can make these decisions for me. I've got wording to the effect of, if I suffer a brain injury from which there's no realistic chance of recovery, I just want to be made comfortable and I want to be left to pass away as comfortably as possible. Now that's my decision. I've been able to vocalise that decision and I know the ramifications behind it. The difference is that if somebody doesn't have the capacity to enter into power of attorney and a deputyship is required, then that is the court giving somebody the authority to consent to that kind of decision, which clearly is very different to somebody being able to decide to enter into that decision themselves. So there's two different types of deputyship. There's financial and there's the personal welfare, which is one we're talking about today. Ultimately, the Court of Protection decides who is appointed. It can be family members, it can be solicitors or professional deputies, but that's usually in the most extreme circumstances when there's nobody else who's appropriate to be named. As a specifically in relation to the welfare deputyship, they provide a Court of Protection with more difficulty because the quite fundamental nature of the decisions involved. As I said earlier, in most welfare matters, the court doesn't need to appoint a welfare deputy and is often reluctant to do so, as decision-making in those kind of situations is more collaborative, or it should be, between healthcare professionals and parents. I think it's impossible to predict how the court would react to a welfare application. You have to request permission to start with, which, as some people in this room are aware of, that permission can be stayed or it can be refused, and there's an appeal process you can go through as part of that element. So I think I wanted to just talk briefly about this children, there's young people, and there's adults. So the age at which your loved one is at is really important, because the Act may not apply to, well, it doesn't apply to children under 16. As I say, so taking me as an example, me and Louise can make decisions for Edith now, which would include consenting to genetic therapy. When somebody gets to 16, they're technically a young person in the eyes of the legislation, and the Act will start to apply. And you can still, again, you've got that parental responsibility, so broadly you can make those decisions for somebody. And I think it's so hard, because it's impossible for me to say that you will be able to make a decision for a young person. Generally you can, but I think it depends on the fundamental decision at play and the context of the particular situation, which can be difficult to assess. So in terms of the people who can apply, it's anybody over the age of 18, usually close relatives, could be friends, or professionals like solicitors, but ideally there should be a specific reason for somebody not involved with the family to be appointed. The application is made to the Court of Protection. There's clear potential for disputes. I'm normally faced with these kind of applications with blended families. So we all know the pressures of raising children are extreme for parents, let alone a SEND child. And unfortunately, I think there's a higher prevalence of people getting divorced because of this kind of pressure. In those, it doesn't take a rocket scientist. In those situations, one parent may wish to be a deputy, another parent might not want them to be a deputy. As part of the process, you have to notify people who may have an interest in being notified. And again, that can then lead to further court action or appeals or arguments, all of which is time-consuming, expensive, and clearly it's not in the young person's best interests for that court process to drag on indefinitely. When I didn't really want to go through all of the process of making the application, there's plenty of forms that you will have to fill in. I think it's really important to recognise that in terms of a welfare and any deputyship application, you as parents don't need to pay a solicitor to do this. You can make the application yourself. Some people see the value in legal professional, but it can be expensive. And I think it's important that you can educate yourselves at that time. Google is a wonderful tool. Be careful with it, obviously, don't need to say that. But it's something that you can do, and you don't need to go to the extremes of making that payment to somebody else. So on taking up the appointment, the deputy assumes a number of duties and responsibilities and is required to act in accordance with certain standards. So deputies have to follow the Mental Capacity Act's statutory principles, make decisions in the best interests of the person, have regard to the guidance in the code, and only make decisions the Court of Protection has given them authority to make. again, it's important to recognise that the order you get from the Court of Protection doesn't give you carte blanche to make every single decision in relation to that person, because every decision you make is decision and time specific. So it's always having in the back of your mind, is this decision in my young person or my young adult's best interests? It's going through that process. You need to evidence that process as well. So again, it's an extra level of responsibility because you're a parent and then you're a professional deputy, and I think the two can't be mutually exclusive. If the powers from the Court of Protection aren't wide enough or aren't specific enough for you to make specific decisions, then you would need to apply to the Court of Protection to ask them to make the decision or ask them to change or amend your powers. I think for me, one of the key ones is obviously genetic therapy. So when you make a professional welfare application particularly for somebody who's over 18, you need to specifically ask for reference to being allowed to give or refuse consent to genetic therapy. We'll come on to that in a bit also. I think it's really important to focus also on the fact that a deputy's got lots of powers, but there are restrictions. Now in my notes I've picked out some key ones that I think are really important. One of those is a deputy cannot refuse consent to the carrying out or continuation of life-sustaining treatment in relation to the person. So you need a specific order in relation to that, and that can of course be potentially quite urgent dependent on the context in place. So I've recently been involved with a couple of stayed applications. So this is when parents have made an application for a personal welfare deputyship for a young adult. He's just turned 18, so they started the process, made the application when he turned 18. He doesn't have Rett Syndrome, but he's got quite significant genetic problems. So it's quite hard to be objective because of my personal situation, but you do your best, of course. Context is really key. So each of these applications runs on its own merits. I think it's important. You'll often hear from legal professionals that it's really difficult to get a personal welfare deputyship. You know, you can just make those decisions, rely on the medical professionals. That's all well and good. I don't tend to take no for an answer particularly well. So I think it's in terms of positivity, permission, the refusal of permission is not necessarily fatal to an application being successful. So with the stayed application, my job was, well, how can I argue against the stay so that this permission can be granted so we can get this deputyship through? The Court of Protection, the base position is that the preference is a decision of the court is to be preferred to the appointment of a deputy, and the powers conferred on a deputy should be as limited in scope and duration as is reasonably practicable in the circumstances. It's difficult because I said the court doesn't necessarily like giving permission for these applications to go through on the basis that the fundamental decision over what happens to somebody's self and body should be made by that person. If a person lacks capacity to make that decision, then why is it the court, well, whose place is it to allow that decision to be made? I personally think that allowing the Court of Protection to just have carte blanche to make their own decisions can really lead to a less personalised approach to care. There's a case that called Re Lawson, Mottram and Hopton, which I put in my notes from 2019, where Justice Hayden emphasised that there's no presumption against the appointment of personal welfare deputy. But again, it's the difficulty is it's the balance between the dual obligations to protect the person and to promote their autonomy. Now, I wish to promote Edith's autonomy as best as I can, but it's difficult to know how to do that if she's not able to communicate that to me. So the COP position can be broadly summarised that the desire to extend parental responsibility is a natural parental instinct, so extending it past 18 by imposing the overly protective legal framework, which is the deputy. The argument from the Court of Protection is that you risk inhibiting the person's personal development. Now, that's a difficult place to be in, because it's all well and good for somebody to say this in a court case who doesn't have a child who suffers from additional needs. And again, it comes down to context, because I want to promote her autonomy, but equally I feel like myself and Louise are best placed to make those health decisions for her, because fundamentally, certainly at the moment, she's incapable of making those decisions for herself. I think one of the key arguments against a stayed application or against refusal of permission is that you as parents, and again I say you or me, as parents or carers, we are the key fulcrum and translator for our girls, and you need to demonstrate this level of need and involvement on behalf of the person to enable you to be successful with an application. So I very much believe that with Edith at the moment, me and Louise are the ones best placed to understand what she's going through, what she wants, what she says. She normally wants food. And we can communicate that to the medical professionals who are wonderful and do their utmost for my daughter, but they don't see her every single day. So without mine and Louise's involvement as that fulcrum for her care, she won't get the care that's best for her. Ergo, it's not in her best interest for us to not be involved as the fulcrum with her care. I think another argument for a successful application, or to argue that permission is allowed, is it is quicker, easier and less restrictive for Edith, both now, in the past and in the future, to allow me and Louise as the proposed deputies the authority to continue to make personal welfare decisions for her past 18. And I think it's a case of, for the Rett girls who are now over 18, it's having an eye on the fact that even though they're over 18, the parental responsibility has ceased. It's still quicker and easier for a parent to make a decision in relation to a Rett girl than it would be for somebody in an emergency department, for example, to do so. I had a key quote from one of my clients, which I was given permission to share, is that we were successful with an application for her, and this paragraph I think is integral. So throughout her daughter's lifetime, I've been able to provide input to help medical professionals successfully conduct tests or provide treatment for my daughter where, without my personal advocacy and knowledge, such things were at the edge of being abandoned due to the complex nature of her medical and behavioural problems. Again, it boils down to, it's that level of such significant involvement in somebody's care that without me and Louise and this client there, then their daughter will not get the care she needs and deserves. So I found this whole weekend, as I said, well, as my wife knows, really emotional, actually. And having to wait to the end, which is absolutely fine, it's been a little bit stressful, because it's all well and good seeing clients in the office or at home and being able to be objective about it. But I really hope what's come across is that I'm not objective about this at all. It's my lived experience. I love my daughter more than anything in the world. So I don't think I can be expected to be objective when it's such a subjective thing. I think the key thing I want you to take away from today is don't lose hope about making a personal welfare application, because just because it's difficult to obtain the deputyship order doesn't mean that it's impossible. Like I said before, it comes back to, I don't like being told no. And if any of you are told no, please reach out, because I'll quite happily have that argument with you and for you. So each Rett parent is clearly the fulcrum from their child. From personal experience, I know we can't rely on our medical team to translate Edith's needs. So me and Louise, mainly Louise, are quite clearly the individuals best placed to do so. One of the key reasons we're all here this weekend is to hear about genetic therapy and the hope of a cure for our girls, whether they be under 18, close to 18 or over 18. So a key requirement in any kind of personal welfare deputyship application will be to include reference around genetic therapy, particularly for those of you who have children over 18. I personally think it'll be very difficult for you to agree to entering your child or your adult into genetic therapy without a deputyship order in place. So although the gene therapy isn't available yet, with an eye on the future, don't waste any time. Start thinking about these kind of applications now. Even if permission is refused, you're then not precluded from making a further application in the future. Now, a refusal may come around because there isn't a treatment available at the moment. Fine, use it as a basis, and then when there is treatment, which I know categorically there will be, or I hope, obviously, don't hold me to that, then you're best placed to be involved with any kind of treatment. So reference to genetic therapy, as I said earlier, needs to be specifically included within the deputyship order itself. If not, then a supplemental order will be required. When you make an application for a deputyship, there's an opportunity to include a draft court order. In my experience, if you save the court a job, they're more likely to give you permission for the application to be made. So I did one about 18 months ago that was successful for a different adult with a different genetic problem. And we had a draft order. I'd already done one, which we got a barrister, so got counsel's opinion on just to see if it was appropriate. And it got through with a few tweaks. And I think the feedback we got from counsel was the fact that we'd taken the effort to do that made it easier for the court. Ergo, they were happier to grant the application. So the court will only appoint a personal welfare deputy in the most difficult cases. Examples can include, like I said, when there's history of disputes, when somebody's at high risk of abuse, or when there is a need for someone to make a series of linked welfare decisions. I've come back to that point because I think that's another fundamental element to include in any kind of application. Finally, when making an application, arm yourself with specific examples of why you need total ongoing authority to make welfare decisions. For example, repeated mistakes by doctors or social services. A good place could be to consider the most serious domains as assessed under any kind of CHC application or framework. I think fundamentally the load on a Rett parent is huge, but to successfully argue whether for permission or on appeal that the welfare deputyship is needed or required, you do need some extremely specific examples which demonstrates that without you acting as the fulcrum, the person's care would suffer. Now, I'm sure for those of you with adult children, you've got hundreds of examples you could give where you acted as that fulcrum, but I guarantee you haven't written them down. So for those parents with younger children, start writing them down now, build up that evidence base, because then when you make the application yourself, or you're sat in front of somebody like me asking for the advice in which to do so, one of the first questions I'll ask you is, where's your evidence? Give me the evidence, feed me with that information, and it's my job to then focus and narrow it down to make the best possible application for you. And just finally, I'd say, hopefully that was helpful. I'm here for a bit of lunch, then we've got to nip off to the train. The notes will be shared by the team here early next week. Other things to consider are things like wills, disabled person trusts, powers of attorney for you as parents. So I know for me and Louise, if I lost my capacity, or I had a stroke or got hit by a bus, or in North Dorset normally a cow, something like that, you laugh, but it does happen, then who's going to look after me, let alone look after my children? So I think there's wider discussions to have rather than just the welfare deputyship. So if you've got any questions, please put your hand up. Feel free to let me know. Catherine?
Sorry, my question is, if you're at a point where your child is over 18 and you're putting in a request for welfare deputyship, should you also, or is it better to put them in separately, say financial deputyship as well?
Yeah, do them both at the same time. I think with financial deputyship, obviously that's not the subject today, but you don't need permission for a financial deputyship application. So if you've not got that in place already, you can make a financial deputyship application for a child, so somebody under 18, if they're going to definitely be a judge not to have capacity, or you prep it for when they turn 18, get the application in, and then you can make those financial decisions for somebody. So for Edith, she receives DLA. So I'm the appointee for her benefits. That continues past 18. If she receives money from my mum, for example, which she won't, but let's argue she does, then technically I can't manage that, or I can't manage any kind of other account in Edith's name unless I've got a deputyship order in place. So with one head on the future, the older she gets, then that's when I'll start preparing the application. But because she's got 14 years to go, that's very much a future map problem, and I'm not going to worry about it now because I just want to focus on her and her needs and what we can do to make her happy. So yeah, was that okay, Catherine? Yeah?
Yes, thank you.
Hi.
So you referenced you may have to refer to gene therapy when you're making the application.
Yep.
How do you provide proof, if any, at the time of consent that you have the authorization for gene therapy?
I think that's a really good question. It's when I've done my one 18 months ago, it was a general reference to genetic therapy. I can't go into what therapy it was or the client, but it was a bit further along the line than we are here. But I still think if you've got your application prepared and it's referenced to genetic therapy potentiality in the future, then it may get accepted, it may not. And if you don't pop it in, then it's definitely not going to be included.
I applied for my daughter, and the Personal Welfare, and we gave this as one of our reasons. I don't know whether it would carry the whole deputyship alone, but it was one of our reasons. And so in the court order they put it in specifying, but if we wanted to, for the I think it says something like for the exclusion of doubt.
Yep.
This involves consenting to treatment, genetic therapy, clinical trials, that kind of thing.
I think that's a really important point, because for a welfare deputyship, it's not just useful just for genetic therapy, it's useful for all sorts of different things, like interventionist surgery, all that kind of stuff, or just being able to make health decisions for somebody to avoid them having to go into hospital if they don't need to. Hi.
Hi, you talked about evidence. I'm a bit unsure about that because, when we think about scientific things, evidence means I did a research, I did this experiment. How do we evidence that I've been looking after this person this many years? I mean, are we expected to keep a record of all the appointments I've been attending with this person?
I'd say with the application we were successful against appealing, it was some very specific examples of when, without the intervention of the parent, then the person's care would have suffered. So this family had some really specific examples of subpar care. So doctors making mistakes, social services, particularly in this instance, making some absolute howlers, which I can't go into. And they were very apparent examples. And it just adds weight to an application. So for me and Louise, what I'm training to do, certainly just mentally at the moment, is keeping a record in my mind of, okay, well, these are decisions that we've had to make as parents where without us making those decisions, she wouldn't have got the care she required. But it's, you're right, it's quite overwhelming because like where you've got what's evidence, well, evidence is 100 pages, 10 pages, what's better, what's worse, and that comes down to context, where without the context, it's impossible to say. So I'd say if you've got some really specific examples of subpar care or decisions that have been made by social services or the doctors which have resulted in harm, for example, fantastic example for why a parent should be involved as the fulcrum for care. Yeah, sorry, that's a bit woolly. Yeah, like I said, quite nervous. So. Any other questions?
Just a small one. Do you have to wait till they're 18 to begin application, or do you start at 16 when they're done?
So for a financial one, you can make the application prior to 18. For welfare, it's after 18. So what I've said recently to somebody is make the preparation. You can fill in the paperwork, get it all ready, and then as soon as where we did this a day after their 18th birthday, dated it, banged in the application, and then watch this space really. So, but it just takes out some of that time pressure because it's very apparent with this young person they don't have capacity whatsoever. I'm hopeful that by the time Edith is 18, she can call me all sorts of names under the sun, certainly say no. So then she can look after herself and I don't have to bother, which is the ideal. But if not, then you're kind of assessing it at the stage as she gets a bit closer to 18. Yeah.
Matt, I just wanted to ask that bit you said inside the deputyship application where you talk about genetic treatments coming to market. Should we specifically say that genetic treatments in Rett syndrome should be used across the age span? The reason I'm saying this, I don't want any smart judge to come across who may have read that most gene therapies is going to be done in young kids, but I personally don't think that's right. It should be done. So could you say that, say if your child is like, you're getting capacity when they're 18 years above, could you say it's just as important they would need the genetic therapy regardless of the age, whether they're 30 and 40 and
Yeah, definitely. As Rachel say, it's with the welfare deputyship, it's there to enable a tool to do all sorts of different things. Obviously, I'm focused on genetic therapy for me because that's what you hang your hat on. But you're right. I think it's having it in as something that, if appropriate, because fundamentally you can't make a decision as a deputy about life-sustaining treatment or make a decision for somebody that's going to result in harm, which giving somebody genetic therapy might result in harm. So it's having the authority to do so as more generally, I think. But if there is some specific evidence, I think then that would help give weight to an application.
I think there is data that, because a lot of these gene therapy trials, they say the earlier you do them, the more effective. I don't think that's the case because it's just as important for Rett patients, like when they get older, they may have like Parkinson's-like symptoms or end-stage motor deterioration. Gene therapy could have a fundamental role to clinically stabilise those patients. And I think it's just as important to put that in, say, regardless if you're 30 and you're getting capacity at that age or 80, I think it's important to say that gene therapy is coming on the market, shouldn't just be used in young kids, and we shouldn't forget about the older kids. It's just as important to do it, but I think it's important because from my experience, I've seen from the patients who sent us the deputyship application, we have to put a lot of information, and the worst thing I don't want to come across, you have this like smart addict who is reviewing the application, who's read about gene therapy, so maybe they shouldn't because it's only been effective with young kids. So I think it's important. I think,
definitely. And as part of the application process, you can include evidence from people such as yourself to say, well, actually, this does apply not just to the young person, but to the over 18, over 25, over 30. I think by adding that weight, that can really help with getting that permission for the application to be made. Yes? You said you wouldn't ask questions, so can you please not...
Is the deputyship, once it's in place, is it lifelong until something happens to that young person or the deputy themselves?
Yeah, so deputyship is in place for life. So if it was me and Louise, it would be on something called a joint and several basis. So if I died, then Louise could continue to make those decisions for Edith or vice versa. If we both popped our clogs, then somebody else has got to apply to be a deputy. And just because we're deputies for Edith already, then there's no guarantee that somebody else will get permission. I mean, it's not a perfect system by any stretch of the imagination. I've just assisted with a welfare application that's been in for a while for parents who are now in their 70s. So they said, well, we want our children, so the siblings of the now adult person, to be deputies because the parents are getting older. And it's not so simple as phoning up the court and adding somebody onto the document. You've got to go through the process again, and the court can say no. I think it's unlikely because it's demonstrating need and it's clearly in the child's best interest for their siblings to be named because they're already involved in their care. So it's just hoping that the court actually is sensible, which isn't necessarily the case, but I'm hopeful that one will get popped through. Is that okay, Louise? Great, cheers. Any other questions? Am I free to go? Thank you so much for listening to me today. I've been really quite nervous for the whole weekend, and a couple of glasses of wine last night didn't help. even though maybe I should have had him today. But I'm always available. I love this area of law, particularly in relation to EDIS associated stuff. I'm passionate about it, and I'm passionate about this community. So thank you for your time. Cheers. Good job. Is that all right?
Very good, very good.